Once again, it's Trial Tuesday. Court isn't the only option for settling legal matters. Attorney David Aylor, the definition of a defense lawyer and my personal legal hero, is here to talk about mediation and arbitration. Counselor, thank you so much for coming. We appreciate that. Let's start with mediation. What's that all about?
Well, mediation is something that is used very often in a couple different settings. Probably the most setting that you're going to see it in is family court settings. Basically, what will end up happening is after a case has been filed, the two parties can't come to an agreement, which, as you can imagine, is pretty
Quite
often.
common.
Exactly. And they'll go to a mediator. In fact, a lot of counties and circuits will actually basically force you to go to a mediator through a judge's court order prior to actually going to trial. And what that mediator will do is get in the middle of your problems and try to solve them.
What's the advantages of that as opposed to just going straight into a trial?
Well, there's a lot of advantages. First and foremost is probably the financial advantage. Getting prepared for a trial and actually conducting a trial is going to be very expensive for both sides, and it'll be pretty traumatic, emotional, that sort of thing. A different type of trial, of course. You're bringing out everything about each other in that situation, and often that'll leave some pretty big scars between the parties that then may have children or a business or that sort of thing to handle. But when the mediator gets involved, he or she is going to know the file before they walk into the situation. Usually the two would be sitting in different rooms with their attorneys and really just kind of try to hammer something out for them. And you'd be surprised how often that two people that really can't even stand to look at each other end up coming to an agreement with the help of that mediator.
Yeah, that third party is so big. Let's talk about the other one, arbitration as well, correct?
Well, arbitration is something you're going to see in different realms, but also, again, it's something you'll see a lot of times within the family court setting or maybe a business type of, conflict case. And basically what happens there is, as opposed to going to a trial or putting it in front of a judge, the two parties can conduct almost a trial within, an arbitration setting. And what an arbitrator does is listens to both sides, can listen to live testimony as well as sworn affidavits, that sort of thing. And then the decision the arbitrator actually makes is then signed and, put through the court system. It's like a judge's opinion, essentially, and it's a ruling, but it's done by the arbitrator. A lot of times mediators are arbitrators, so somebody may be the mediator in a case, an agreement can't be made, they'll come back and do an arbitration. Again, even though it sounds repetitive, it's still a lot cheaper than trying to go through the actual trial process and gets done a lot quicker.
How does a lawyer such as yourself agree on who actually gets to mediate or be the arbitrator in an argument like this?
Well, that's a good question. A lot of times, if it's not court ordered by the judge, meaning y'all need to go to this mediator, that sort of thing, the two attorneys will work together. Here in the Low Country, there's a handful of mediators and arbitrators that people used often, just like any other type of service. They build their reputation up, and a lot of lawyers feel comfortable with them. Then you have new lawyers coming in. Sometimes arbitrators and mediators will come in from out of town. There's a variety of ways, but at least in the Low Country community, we have some great ones.
Is there any way to prepare for that arbitration or mediation?
Well, with the mediation, you're going to have to do less preparation, but more just collect your thoughts, have your documents together, that sort of thing. Be ready to kind of hit your fine points and not go through 15 years of family stories. With arbitration, it's going to be a little bit more of a structured approach than what's agreed to with the attorneys and the arbitrator as far as testimony, whether it be live or affidavits, what can come in, what can't, that sort of thing.
And let's say it doesn't work, your attorney can definitely point you in the right direction to get that trial decision later on down the road.
Correct. Sometimes people aren't comfortable with, they don't settle with the mediator, and they're not comfortable with arbitrators, so you still can always have that trial in front of a judge or jury.
But basically, they're problem solvers just like you are. Attorney David Aylor, thanks so much. We appreciate it, sir. More Low Country Alive just ahead.